Our next case this morning is ALVIN OLESH and PATRICIA GREENBERG. Good morning, sir.
Good morning. May it please the Court. John Hamilton on behalf of the appellant ALVIN OLESH. I'd like to reserve 4 minutes for rebuttal, if I could, please. I have not been able to find, and I have looked, any reported case in the state of Florida in which a judgment for attorney's fees that was predicated on an underlying judgment has been left intact or been allowed to remain in place.
I mean, the only real issue is, I think we would all agree, had your client appealed the underlying attorney's fee order in a timely fashion, given what happened in the case, he would have gotten a reversal. So really the only issue is it as a matter of law, I guess, or is it a clear abuse of discretion on the part of the trial judge, given these circumstances, not to give him relief from judgment?
I think that's probably true. It takes me to the standard of review. I mean, there are any number of cases that say orders on motions for relief from judgment under Rule 1.540 are reviewed for an abuse of discretion. I think the case law, however, here treats this scenario in which an underlying predicate for a later award of attorney's fees treats that more as a rule of law, that when the predicate disappears, when the foundation is gone, everything built upon that foundation must fall as well. I think that's an error of law, and there's Florida law to the effect that when a trial court commits an error of law, even in the context of what is otherwise a discretionary determination, that error of law is subject to a de novo review. And so I think that's what we have here. We have an error of law that consequently resulted in an abuse of discretion in denying this motion. And if you look at the language of Rule 1.540B5, and in its reference to allowing for relief from judgment when the underlying basis for that order or that judgment has been reversed or vacated, I don't know what other context would be more appropriate for granting relief from judgment than the scenario that's presented here. It seems to me that's precisely what it's designed for, and that's exactly the way it's been applied in the case law. As I say, it seems to me to be a rather uniformly applied and consistently applied principle of the Florida courts that when that does occur, the courts are required to set it aside, and that's logical. There's really no legal basis for keeping it in effect. The appeal of the judgment itself, if Mr. OLESH had appealed from the fees judgment, he could, we mentioned in the brief that there were legal errors that he potentially could have appealed from, but at that moment in time, he wouldn't have been able to say, and you also should reverse this judgment because you have already reversed this underlying summary judgment, because at that moment in time, that judgment had not been reversed yet. For whatever reason, he did not appeal from that judgment. But that doesn't bar him from relief later on when that judgment was reversed. That's precisely what the rule is designed to address. That's precisely the relief that is afforded by that rule. And that's when it kicks in. That's when it comes into effect. And that's what he did. He, even before I think it was within 3 days of the order reversing the summary judgment from this court, he filed his motion, his first of the 2 motions for relief from judgment. Filed a second one after the court's mandate issued. Wouldn't
it be wiser for your client to put a little bit of money into attorney's fees? He did that pro se. I mean, if you were representing him, below, I think that this is a little different specter to the case. A little different procedural history would be involved, and it seems that's part of the problem here. Is that he's trying to represent himself for some things alone, and then for other things he's hiring counsel.
Well, I think that is part of the problem here. He had the unfortunate experience initially being represented by Mr. Moss, who's been disbarred now, and then the court in the prior case recognized the consequences of that unfortunate engagement. We represented him briefly, and then we withdrew because of his inability to pay our fees, and he tried to take it pro se for a while. And one of the consequences, I think, of trying to do it pro se is this order. I Obviously, I can't know whether the judge would have ruled the same way had he been represented by counsel at the hearing on this motion, or whether the judge would have ruled differently. I have speculation in that regard, but I have no doubt that it would have been presented more professionally had it been presented by an attorney. But I don't know that that makes a legal difference. He did file a motion that cited the right rule, quoted from that rule. He made the right argument. He attached to that motion the legal basis for the relief he requested. That is the decision from this court that reversed the underlying judgment upon which this judgment for attorney's fees was predicated. That is really all you need, I think, to show an entitlement to relief under subsection B5 of Rule 1.540. Is it unfortunate that he was pro se at the time? Yes. Does it mean he's not entitled to relief? I don't think so. And I don't think that meant he was entitled, precluded from relief either in the trial court or certainly not in this court either. The legal issue remains the same. And I think the error of the trial court remains the same. Now, it seems to me the question becomes, in light of a fair amount of case law that I cited in the brief as to when these reversals occur and when these judgments based upon other judgments had been set aside, I think the question, and in the complete absence of any case law to the contrary, I think the question becomes whether there's anything special about this case to justify the departure from the trial court from the general rule. And fortunately, we have an order here that sets forth 8 reasons why the trial court denied this motion. And if you look at all of those and go through them, I don't think any of them can be reconciled with the law. I don't think any of them really can support a denial of this motion. Some of them are flatly contradicted by the record. Others are legally irrelevant. For example, the trial court included a finding that there was no testimony or exhibits. Testimony, perhaps we don't have a hearing transcript, but I accept that as a given. But the exhibit is attached to the motion. It's a motion that's based upon B5 of Rule 1.540, based upon this court's decision. I don't know what other exhibit is necessary to show entitlement to relief under that subsection of the rule. The order says that there's no, in the second paragraph of the order says there's no legal authority cited for relief. Yes, there is. You can look on the face of the motion and see that he cites to and quotes from 1.540 B5. Third paragraph of the order which says that Mr. OLESH made no showing for relief under Rule 1.540. Again, the face of the motion itself refutes that. He made the right argument. He referred to the appropriate section of the rule. That's all the showing you need. The fourth and fifth paragraphs of the order are somewhat perplexing. There's a reference to Mr. OLESH's failure to respond to discovery requests, failure to obey court orders, and failure to appear at hearings. I'm not sure what that means. At the time of the attorney's fees judgment, and at the time of the earlier summary judgment hearing or summary judgment order, Mr. OLESH had been represented by Attorney Moss, and there's no record evidence as far as I can tell that Mr. OLESH failed to appear at any hearings. And even if so, or that would have been attributable to Mr. Moss anyway. And if the judge below in this case was referring to post-judgment failures on the part of Mr. OLESH, I don't know that there's any possible legal justification for using those failures as a rationalization for retroactively justifying the attorney's fees judgment or serving as a basis for denying a motion for relief from that judgment. As best I can tell, there have been a total of 15 hearings in this case, and you can look at the docket, which is tab A in the appendix. And as far as I can tell, there were 3 hearings at which Mr. OLESH was pro se, all of which occurred after the attorney's fees judgment was entered. and 3 that he did not appear at, one of which was the hearing on the attorney's fees judgment itself. And I don't know that any of them particularly have any bearing upon this other than the consequences of failing to show up for the attorney's fees judgment or the hearing on that motion. One of them resulted in was on a motion to compel filed by Mr. Lang. It was on March 17th, 2008, and it resulted in a $500 sanction for Mr. OLESH's failure to respond to, I guess, post-judgment discovery. But I don't know that any of that has anything to do with whether he was entitled to relief under Rule 1.540 for the earlier, much earlier motion judgment for attorney's fees. I just don't see the legal relevance of the failures that are being discussed at that portion of the order. And I would also suggest that that there are other remedies available to a litigant for a party's failure to respond to discovery than a sanction of $115,000 in attorney's fees. The next paragraph of the order, paragraph 6 of the order, says that there is a reasonable basis for the award. Well, no, there's not. The reasonable basis for the award was the judge's finding, sua sponte finding at the hearing on the motion for summary judgment that this was a 57-105 case. As we saw, as this court found in the later decision, there was a basis upon which that motion for summary judgment could have and should have been defeated, should have been denied if his counsel had acted competently and diligently in opposing that motion for summary judgment. This was not a 57-105 case, and there was not a reasonable basis for this award under 57-105. The paragraph 7 was to the same effect, that this was an award under 57-105. 57-105 is inapplicable here once this court made a determination at page 243 of the opinion in the Southern Reporter citation that the facts submitted after the summary judgment in that case and the evidence submitted, if true, would have not only defeated summary judgment but shown an entitlement to relief by Mr. OLESH at trial, which was part of the reason why the underlying summary judgment was reversed. And then the final finding or ground for denying the motion in the trial court's order was the fact that, as you referred to, Judge Cohen, that Mr. OLESH didn't appeal from the underlying judgment itself, which is true, but once again wholly irrelevant, because he wasn't seeking relief from the judgment on a ground that could have been the subject of a prior appeal. He was, in fact, seeking judgment on a ground that was independent of what could have been available to him on a prior appeal, that is, the underlying judgment having been reversed. And I was thinking about this earlier. You know, if, and this is contrary to what happened here, but hypothetically, if the summary judgment had been reversed before the fees judgment had even been entered, then we probably wouldn't have this issue at all. The fees judgment would, and I'm going to say this wrong. If the fees judgment had been appealed at the same time as the summary judgment, the two probably would have traveled together in this court, and the two probably would have been consolidated, perhaps, and probably would have been disposed of in a single order. And there's any number of cases cited in the brief where the courts, including this court, have disposed of those by saying, okay, because we're reversing the judgment on the merits, we're also reversing the judgment for attorney's fees. But if you separate those in time, such that the judgment on the merits gets disposed of by the appellate tribunal before the judgment on fees is appealed, entered, ripe, then there's no particular reason to assume that the attorney's fees judgment is going to be disposed of at the same time as the attorney's fees, as the judgment on the merits. And I don't know that there's any particular reason legally that the two must be tied together, and I don't know that there is a legal requirement that the attorney's fees judgment be appealed at the same time as the judgment on the merits. It seems to me that that's an imprudent proposition of law if somebody tries to urge that. I mean, this particular attorney's fees judgment had some reversible error within it, but hypothetically there could be one that didn't. And it seems to me unwise to suggest that a litigant must appeal from a judgment of that nature in order to preserve its ability to seek relief from that judgment in the event the underlying judgment on the merits is reversed. I think the better approach from a policy perspective is to assume that Rule 1.540B5 will operate as it's written, and that if the underlying judgment on the merits is reversed, that the judgment debtor will then be able to ask the trial court and get from the trial court a relief from the judgment for fees. In other words, I don't think that the failure to appeal the the fees judgment has any bearing upon his entitlement to relief from the fees judgment at all. I think this was error. I think it was an indefensible ruling, and I think it should be reversed. And I'll save the rest of my time for rebuttal.
Thank you, sir. Good morning.
Good morning, Your Honors. May it please the Court, my name is Mark Lang. I represent the interest of my former client, Patricia Greenberg, and the interest of my firm in seeking the affirmance of the trial court's order denying the motion for relief from judgment, the judgment being an attorney's fee award for a portion of the fees billed by a prior firm and my firm in representation of Miss Greenberg in the first trial, if you will, the first phase of this case, which was subsequently reversed by this court and sent back for another edition. After that reversal, I did withdraw. I think the critical thing that's missing here is Mr. Hamilton's belief that or argument that the underlying fee judgment is based on the summary judgment, final judgment. And that is simply not the case. There are multiple bases for the trial court's finding of a fee award. In fact, it's obviously that the plaintiff's behavior throughout the course of his attempted prosecution of his claim for an interest in real property without any piece of paper supporting that claim whatsoever. And it was Judge Adams' own motion at the summary judgment hearing, based upon the conduct of Mr. OLESH throughout this case, not just Mr. Moss, upon which he, on his own motion, awarded my client her attorney's fees of this, what could only be termed a debacle. So the fee award was based on the plaintiff's conduct, and the judgment says that the fees and costs are awarded to defendant in tax against plaintiff pursuant to 57-105 or otherwise. And it's interesting to note that the fault cannot be all placed on Mr. OLESH's attorney, because for some reason Judge Adams determined that these fees should not be taxed jointly against counsel and his client. You know, we have an obligation to the court, not to suborn perjury. And there may have been very good reasons Mr. Moss did not put forth certain items of evidence because of his obligation for candor with the trial court. These matters are not in the record. What I think is important here is that if Judge Adams was wrong on the law, I'm looking at Florida Bar CLE, quoting the Supreme Court case of Cervello, 571 Southern 2nd, 443. A trial court's mistaken view of the law is not one of the circumstances contemplated by that rule. Mistakes of law must be appealed. And the rule itself, 1.540, under subsection B5, states that, and that's what Mr. OLESH is relying on, is that the prior judgment should be set aside if it's upon that prior judgment that the fee award is based. That's not the case. The transcript from the first hearing clearly reflects Judge Adams' total disgust with plaintiffs' handling and bringing of this action to reform title to real property without having one single piece of paper whatsoever to support it, not complying with any discovery or request, not appearing for hearings, and on and on and on. Simply put, the trial court had had enough. There is nothing wrong with separating a fee award for bad conduct in phase one of a case that is later reversed from the ability of that party to go back and have a second chance based upon this court's finding that he should be given a second chance because of some later discovered Xeroxed copy of a Xeroxed signature that might provide a scintilla of proof to aid him in his quest to reform the title to real property. Why should an innocent party have to pay twice? My client should not be required to pay for the first chance that Mr. OLESH clearly abused and thumbed his nose at the system and the trial court and the trial court's orders. So Mr. OLESH should have to pay for his behavior and conduct in round one.
Was the $115,000 award for all the fees that were incurred by Ms. Greenberg in the litigation, or was it premised upon what the court found to be the litigation misconduct of Mr. OLESH?
The fee award was for a portion of the fees billed by Ms. Greenberg's prior law firm and my law firm after the judge took expert testimony on the reasonable value of the services performed.
What was the total amount of the fee that was sought?
To the best of my recollection, Your Honor, it was between $165,000 and $185,000.
And he concluded that $115,000 and change was the appropriate award. I guess what I'm trying to separate out is I don't think I disagree with you that somehow if Mr. OLESH is engaged in misconduct in the litigation, failing to show up for depositions or respond to discovery requests, that he should somehow get a free pass. I got the impression from reading the order, though, that this went well beyond that. I mean, I have a hard time believing that it was $115,000 worth of missed depositions and document problems in discovery. It seemed like the judge was pretty much finding that during the scope of the litigation, he thought $115,000 was a reasonable fee and hit him with the whole amount. So I guess what I'm trying to separate out in my mind is the idea of should it be whacked with the whole amount. Am I wrong that essentially the $115,000 that was awarded was the judge's view of a reasonable fee for the entire litigation?
No.
Or was it the judge's view that $115,000 was the appropriate amount for the missed depositions or late discovery or otherwise general horsing around that Mr. OLESH may have engaged in? Because that's not clear to me from the record.
That may not be clear from the record, Your Honor, but that is my position and my belief that as to what the judge ordered. You know, a lot of cases become like whack-a-mole, and Mr. OLESH was admonished in July of 2006 because, you see, he filed a lease pendens against this property when he filed his lawsuit to restate the title to the deed, and he was admonished at the hearing that in July of 06, the final hearing was in November of 06, that if he doesn't come up with some piece of paper, that there's going to be a price to be paid for clouding the title on this real property. I think the coup de grace was at final hearing. One piece of paper was offered by Attorney Moss, and it was an original letter authored by ALVIN OLESH that came out of an original envelope addressed to my client, Ms. Greenberg, that had never been mailed, and it was produced at the hearing for the first time, and Mr. Moss in the transcript of that hearing states, "I just received this from my client," and it's a self-serving letter that says, "This will confirm your agreement that I own this property." The judge refused to accept that into evidence because it had not been produced to me, nor provided by affidavit in accordance with the summary judgment rule a couple days before the hearing.
Were there expert witnesses called to testify as to the attorney's fees?
Yes.
And did they separate out misconduct from other fees?
No. So having been there, again, I did not ask for 57,105 fees. But at that point, it was clear that the judge had had enough. And it wasn't until post-summary judgment, when Mr. OLESH hired my eminent colleague, that this Xerox copy of that letter was mysteriously, miraculously discovered with a Xeroxed signature by my client on it. And this court ruled in the case that accused me of destroying many, many trees in pursuit of the defense of my client, that this court ruled that he should have a chance to offer that, whether it was a forgery or not, and would leave that to another day. But again, for that 1 year of wasted time and effort, when someone doesn't participate, when someone doesn't play by the rules, he didn't play at all. That conduct should not be countenanced by this court. We need to give the public security and belief in our system, and that there will be accountability for bad conduct, and that we shouldn't just give second and third and fourth chances to people who, in my view, don't deserve it, but that's not my role, with no accountability, with no price to be paid for thumbing your nose at the system and abusing this system when only one side obeys the rules and the other does not. I think that accountability needs to be restored into our system. This judgment's recorded. Who knows what will happen, but I believe it should remain intact. And I believe Judge Adams was within his discretion. In fact, Rule 1.540 in the author's comment says the application of relief provisions is generally within the discretion of the court, except when questions of law are involved. And again, the questions of law must be appealed. So he knew how to appeal. For whatever reason, he chose not to. Again, I implore this court to affirm Judge Adams' denial of the motion for relief from judgment, and restore accountability to the system for poor conduct.
Thank you very much, sir.
Thank you.
Mr. Lang says the judgment for fees was not based upon the summary judgment. The judgment itself provides otherwise. If you look at it on tab N, pages 127 and 128, it expressly refers to the reservation of jurisdiction in the summary judgment to award fees. And it expressly says that it is based upon the determination of entitlement to attorney's fees under 57105 and the offer of judgment.
Would you agree that if we were to send the matter back, that to the extent that there might be some fees related to litigation misconduct, missed depositions, failure to respond to discovery, and that sort of thing, that Mr. Lang would be within his rights to come back now and ask for fees that were related to that, irrespective of the ultimate merits of the case? I mean, even if I don't know who's going to win the case, and we don't know that, but let's assume that there's some discrete amount of money that can be isolated and say, okay, well, he missed 2 depositions and a hearing, and there is $20,000 related to that. Do you agree that that's still on the table if the case goes back?
I can't agree with that for 2 reasons. One is because he filed a motion for attorney's fees setting forth the reasons why he sought attorney's fees, and litigation misconduct was nowhere to be found in that motion. He sought attorney's fees on 2 grounds: the 57105 determination that was made sua sponte by the trial court at the hearing without any evidence, and 2, the offer of judgment that was rejected by Mr. OLESH. That's one reason. So litigation misconduct was not a part of the requested relief, the requested recovery of attorney's fees. Those 2 and only those 2 grounds were why he requested attorney's fees. So that wasn't a part of that wasn't what was on the table in his motion. And it shouldn't be, and it's not reflected anywhere in the order awarding the attorney's fees. On the contrary, the order refers to the entirety of the attorney's fees through February 2007, and it refers to the award being made and being predicated upon the rejection of the offer of judgment and the 57105 determination. Nothing about litigation misconduct. That's not supported by the record at all. The second reason why I would disagree with that is because anything that occurred prior to the summary judgment, I think, has to be squarely laid at the feet of Mr. Moss and not Mr. OLESH. I don't think that there's any...
Didn't you lose your right to argue that when you didn't appeal?
I think if we were, well, I'm trying to respond. The answer, I think, is yes. But if we're sending it back to now talk about the amount of attorney's fees that are still on the table, which I think was responsive to Judge Orfinger's question, then we're, in theory, opening the question of amount of attorney's fees back up. And if we're doing that, then we probably do have to revisit some of the same issues that went into that determination in the first place. I mean, my position is that the judgment reflects on its face squarely, and the record reflects on its face squarely, that the attorney's fees judgment was based upon and only upon the summary judgment that was reversed, and that it can't survive as a matter of law if in the face of the reversal of that summary judgment.
Well, does it, I mean, Mr. Lang's argument is that it might depend on the reason why the summary judgment was reversed. And in this case, what we have is a 57105. I mean, the trial court said, I find on my own initiative that the losing party knew or should have known that the claim was not supported by material facts necessary to establish the claim or defense. And what Mr. Lang, I hear argue, is that that's absolutely right, and it remains correct today. That as of the entry of that summary judgment order, that your client did know or should have known that the claim he was offering, the litigation he had conducted, was not supported by any material claim or defense. And essentially what we did, in our opinion, was to say that may all be true, but now we're giving you a second chance. And so why wouldn't a 57-105 award of fees for, as Mr. Lang refers to it, the wasted year, be appropriate even in the face of a reversal of a summary judgment?
Well, I think part of the answer there, I think I can only get part of the answer in light of the red light that's
Just
flashing
keep talking.
Okay. Part of the answer there is I don't think that you can square that with logic, because a necessary consequence of this Court's determination in the appeal is that there is at least arguable merit to Mr. OLESH's claims. And if you have at least arguable merit, you cannot square that.
I think what the Court said is there is now, as of that date, but up for the preceding year, there was none.
Well, that's not what the Court said. The Court said, with all due respect, the Court said there was all along, and had Mr. Moss had the minimum amount of competence, he would have presented that merit in opposition to the motion for summary judgment, and it would have been revealed and known to the trial court at that moment in time, and the summary judgment would have been denied.
But 57-105 allows the court to award fees for any claim asserted, any defense taken, or any position maintained, papers filed, etc. So, I mean, the court might find, for example, that there was still an adequate basis. Based on our opinion, we obviously said the guy needs you got to give him a chance to be heard, but the court might still be able to find that, 4 papers that he filed didn't have any substantial basis, and 3 of the actions that he took were dilatory. I guess my sense is that it's not an all or nothing under the current version of 57-105.
I don't disagree with that, Your Honor. I think that would be fair game on a remand for.
All right. So with that, we'll conclude the argument, and thank you both very much.
Thank you, Your Honor.